And these are questions now that we're going to talk about for a moment that really aren't defense problems. They're I think, more in the plaintiff's side of the table. But, for example, under the rule to comply, do you have to tell all of your clients about all the medical conditions that all of your other clients have so that they can fairly evaluate the settlement and decide whether or not the money they're being allocated is fair? And I don't know how the plaintiff's lawyers do that, but that's a question. Do the plaintiffs who are jointly represented have an expectation of confidentiality of their medical information one from the other? In other words, in order to evaluate whether the settlement I'm getting as a plaintiff in a group, am I entitled to know the medical information about my co-plaintiffs? And there's an argument that under 1.8, the jointly represented plaintiffs have no expectation of privacy among themselves. And they can compel the disclosure of their co-plaintiffs' medical reports and documents in order to evaluate the fairness of the settlement. I don't know how the plaintiffs' lawyers deal with that, but I think you have to at least confront that. Can the plaintiffs waive in the retention agreement the right to veto an aggregate settlement? There's at least some case law that suggests you cannot, despite the law of contracts, waive your right to evaluate a settlement in advance. Can you make the allocation without the informed consent of the plaintiff, even when you get some judge to approve it? I would think you probably could not under the rules. It would help, but I'm not sure it would be sufficient to prevent a lawsuit from one of your disgruntled clients. The penalty for violating the rule. I've not seen any penalties levied against any defendant for making an offer, although Judge Davidson tells me there's some theory floating around about conspiracy.
I'll talk about it.
Okay. The penalty seems to be lawsuits by the disgruntled clients against their lawyers, claiming that they would have gotten a better deal had there been no settlement, or a lawsuit for breach of fiduciary duty to recover the attorney's fees that were paid. I suppose theoretically the plaintiff could bring a claim to set aside the settlement in its entirety, or at least as to that particular plaintiff. I've not seen that happen. So that's how we view it from the defense side, aggregate settlements. They're necessary, they're important, they're quite useful. Even, for example, if you have two cases where the plaintiffs and the defense lawyer know generally what the value of the cases combined is, but you have a disagreement about how much case A is worth versus case B, it's not unusual for the defendant to say, I'm going to pay you $500,000 for these two cases, but I think I evaluate case A as being worth 100 and the other one's worth 400, and the plaintiff's lawyer says to himself, I think the cases are worth 250 each, and you can't agree on a value. You settle them as a unit, and then the plaintiff's lawyer gets to allocate the money between the two cases, or maybe it's 4 cases or 6 cases. It's a useful way for the defendants and the plaintiffs to get together to resolve the cases if they can't agree on every single case. So it's something that comes up all the time, even in small groups of cases, and you have to do it.